You know it's all a ploy, don't you?
A ploy?
Man, where have you been? Don't you watch TV? We are being set up by rich and powerful cartels.
Oh, come
Now
on.
you got these big fat cats sit there using working class just like me and you. They spend billions of dollars on TV advertisement, and then they sit there and use subliminal messages to suck your children's minds out. And then they sit there and make a kid feel like garbage. If you, the father who's working 24/7, delivering mail so you make an alimony payment to a woman that slept with everybody at the post office but me! You know what I like to do? I like to walk up in that office, grab one of those guys, and just chuck him until his eye pops out. Shouldn't wear fur.
Hey, what's up, world? Hope you're all having a fantastic day, and maybe even a fantastic week like myself. I had a really good week, although I do feel a little guilty. I feel guilty having such a damn good week when I know that there are whole families in other parts of the world who are being bombed every day, who are struggling to find food every day, and whose lives are pretty much like a living hell. Like, I don't believe that this should be the case. I don't think that the world is a zero-sum game where some people have to have and some people have to not have in order for things to maintain a balance. I think that there is a sweet spot that we can all be in, and we're just not there because of the powers that shouldn't be. But anyway, this video is not about that. This video is not about me. It's not about you. It's not about them right now. This video is about why I believe anybody can be a Supreme Court justice. So let's look at this article here, right? This is from the SCOTUS blog, right? The SCOTUSblog.com. The article is titled, Supreme Court Declines to Hear Gun Control Challenges. This was published on June 2nd of 2025. So let's dive right in, right? So after considering them at 15 consecutive conferences, considering, not actually taking on the case, the Supreme Court on Monday declined to take up two challenges to gun control laws in Maryland and Rhode Island. In each case, 3 justices indicated that they would have granted the petition for review, leaving the challengers 1 vote short of the 4 needed for the court to hear oral arguments and weigh in on the merits of their case. Right, so there's 3 of them. They were like, oh, we would have heard it, but we just couldn't get that 4th one, right? In Snope versus Brown, the court declined to decide whether Maryland's ban on semi-automatic rifles, such as the AR-15 and the AK-47, violates the Second Amendment's right to bear arms. 9 other states and the District of Columbia have similar bans. Okay, so they're like, no, we don't want to hear this, or at least a majority of the court. No, we don't want to hear these cases. The Maryland legislature enacted the law in 2013 in the wake of the 2012 shooting at Sandy Hook, in which a gunman, 20 first graders and 6 adults. The full U.S. Court of Appeals for the Fourth Circuit rejected a challenge to the law in 2017. You know, this gunman, if he really was doing that, he could have been stopped very quickly by an armed teacher. You know, if you had an armed teacher in the classroom, but I guess we're not going to digress into that, right? So, anyway, the Court of Appeals of the Fourth Circuit rejected the challenge in 2017, right? But the full Court of Appeals agreed to consider the new challenge in 2024, less than 2 years after the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin. In Bruin, the justices struck down New York's concealed carry law, holding that courts should only uphold gun restrictions in the future if there is a tradition of such regulations in U.S. history. Let's read that again. Let's read this whole bullshit again, right? So, but the full Court of Appeals agreed to consider the new challenges in 2024, less than 2 years after the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin. So in Bruin, this is the Supreme Court here. This is not the Court of Appeals. In Bruin, now this is the Supreme Court talking, right? The justices struck down New York's concealed carry law, holding that courts should only uphold gun restrictions in the future if there is a tradition of such regulations in the U.S. history. This should raise some eyebrows. People should look at this and be like, wait a second, this is not a country of traditions. Okay, we didn't form our Bill of Rights based on fucking traditions. Okay, we created these rights, or these rights were pushed. Of course, James the Conman Madison hijacked them and created the shitty Bill of Rights that we have nowadays. But the anti-federalists that pushed the Bill of Rights didn't push them because they were like, oh, we have a tradition of these rights. No, they pushed them because they're principled. They were pushed because they were self-evident truths. That without these rights, you have tyranny. Without these rights, you have despotism. Without these rights, the people are not secured. Without these rights, we're basically subjects. And then we're not free. So anyway, let's look at this, right? It has nothing to do with traditions, but that's what they're trying to push here. And that's why I want to bring this to your attention, because the fact that these Supreme Court justices said this shows that they don't know shit about the U.S. history. All right, and we're gonna be looking at that in a second. In an opinion by Judge J. Harvey Wilkinson, who was repeatedly on the short list to fill the vacancy created by the death of then Chief Justice William Rehnquist during the George W. Bush administration, the full Fourth Circuit rejected the new challenge. Right, so let's just make sure we're understanding this, right? So the Court of Appeals, they rejected hearing this challenge in 2017, right? But then they decide, oh, you know what, we're going to agree to consider the new challenge in 2024 after this. But then, in their opinion, the full Fourth Circuit rejected the new challenge. They're like, you know what, we considered it, we're going to reject it now. Let's look at what they said, right? So the majority first concluded that assault weapons are not protected by the Second Amendment's right to bear arms at all, because in essence, they are military-style weapons designed for sustained combat operations that are ill-suited and disproportionate to the need for self-defense. Once again, this shows that anybody can be a judge. Now, this isn't the Supreme Court here. This is the Court of Appeals. But this shows that anybody can be a judge, because if this judge thinks that the Second Amendment only has to do with defending yourself against petty criminals, and the Second Amendment isn't suited for sustained combat operations, anybody telling you that the Second Amendment doesn't cover military-style weapons, they should immediately until they admit that they don't know what they're talking about. Because the Second Amendment is specifically for military-style weapons. And I'm sick and tired of hearing this argument everywhere I go. I hear this argument, oh no, automatic weapons were banned. So thus, there we go, we have a tradition. And actually, you know what, before I even reveal the information, let me just read more of this, so I can just take into account all these ridiculous statements in this article. So, but even if the Second Amendment does protect the right to have assault rifles, Wilkinson continued, the law is still constitutional because it fits comfortably within our nation's tradition of firearms regulation. It is, he wrote, but another example of a state regulating excessively dangerous weapons once their incompatibility with a lawful and safe society becomes apparent, while nonetheless preserving avenues for armed self-defense. Here we go again, armed self-defense, talking about this again. And this is also something that I want to say. I want to say that the Constitution, your rights are only secured as long as it's a safe society. Once the society is a little unsafe, Once the general welfare is a little insecure, your rights go right out the fucking window. And you know why that is? Because of this preamble. That's right, this preamble right here. We, the people of the United States, in order to form a more perfect union, that's right, this has to do with forming a perfect union. Don't confuse this having to do with your rights and, creating a good society for people to live in, free of tyranny. No, don't confuse it for that. Establish justice, their type of justice, not actual justice. Ensure domestic tranquility. Once domestic tranquility, once that's a little on the rocks, your rights are out the window. Provide for the common defense. If there's a common defense, if there's something that we need to be commonly defended against, your rights are out the window. Promote the general welfare. Once again, if the general welfare is a little unstable, a little unwell, your rights go right out the fucking door. And secure the blessings of liberty to ourselves and our posterity. Their idea of liberty, though, the blessing of liberty is the blessing of life. The Supreme Court has actually said liberty is life. And thus, if somebody's life is in danger, or if multiple people's lives are in danger, there goes your fucking rights. We saw that with the COVID lockdowns. Our Constitution is trash. The system that we currently have is trash. It's garbage. It's a garbage system, but we're told, oh no, it's perfect. No, this is the land of the free, not the land of the lie. No. Okay, so let's just keep reading this, right? So once again though, talking about tradition, Judge Julius Richardson dissented from the court's decision, joined by 4 other judges, Paul Niemeyer, G. Stephen Agee, Marvin Quattlebaum, and Allison Jones Rushing, stressing that the Second Amendment is not a second-class right subject to the whimsical discretions of federal judges. Richardson argued that the assault weapons barred by the law are indisputably covered by the Second Amendment. And although Richardson acknowledged that history and tradition support the banning of weapons that are both dangerous and unusual, he concluded that the ban was nonetheless unconstitutional because the Maryland law prohibits the possession of arms commonly possessed by law-abiding citizens for lawful purposes. So this is what they're doing. Even the people who are dissenting are f***ing this up. Even the people who are dissenting are committing fallacies. We got a tradition fallacy over here. Now we have a fallacy, an appeal to popularity. Oh, let's appeal to a tradition. No, let's appeal to popularity. Oh, well, look, this is a popular firearm thing, so it's not unusual. No, you need to take a stand, Mr. Richardson over here, and say, hey, this idea that we can ban things because they were historically banned and there's a tradition of banning them is bullshit. Because we've already seen in our history that just because we have a history of doing something and a tradition of doing something doesn't make that something right. And this is the most crazy thing about this, is because not only is this completely fudging up the Second Amendment, this is completely fudging up our history. It's like, wait a second, we had a history of women not being allowed to vote in this country. Does that mean we just keep to that history and we just keep to that tradition? No! That's not how things work. We are not a bunch of mindless traditionalists over here. We are a society based on philosophy, based on principles, based on reason and evidence and logic. Not some society based on, history and tradition. What kind of nonsense is this? The challengers came to the Supreme Court last summer asking the justices to take up their case. They stressed that assault rifles like the AR-15 are the best-selling rifles in the country. They're owned by millions of Americans and have accounted for approximately 20% of all firearm sales in the country for over a decade. And if the Fourth Circuit's decision is allowed to stand, they cautioned, then states could place restrictions on virtually any gun in the country except for handguns. Once again, this is a dumb argument. This is not an argument that's based on reason, evidence, and the actual history of the Second Amendment. Not the history of this country, but why was the Second Amendment pushed by the Anti-Federalist. So anyway, the states urged the justices to leave the Fourth Circuit's ruling in place. Nearly 2 decades ago, in District of Columbia versus Heller, they noted, the justices struck down a District of Columbia law that generally banned the possession of handguns. In that decision, the state stressed the Supreme Court left no doubt that weapons that are most useful in military service, M16 rifles and the like, may be banned. But in any event, the state continued, there is no reason for the justices to weigh in on this dispute now when only one other court of appeals has even considered the question. This is the state now here urging them, right? And this is the state's argument. The state claimed that in the District of Columbia, in this other case, the Supreme Court made it clear, this is what the Supreme Court stated, that weapons that are most useful in military service, M16 rifles and the like, may be banned. Okay, this shows any of these Supreme Court justices that said this, they don't know. And this shows that anybody can be a Supreme Court justice as long as they have the right education. Just do a little education and look at this. I'm gonna show you what ChatGPT says. It's funny, I had ChatGPT read this article, and this, how you can tell ChatGPT, all of these AIs, they still have a bias, like a left-wing bias. Like they all try to lean left, and it's not even actually a left-wing bias. I don't even want to say a left-wing bias. They clearly have something implanted in them that the powers that shouldn't be have implanted to fit their narratives. Now, I'm not talking about the right or the left narrative. I'm talking about the real narrative that both the right and the left push subliminally. So I'm like, what is wrong with the argument based on tradition? That's all I asked it. I'm like, what's wrong with the argument based on tradition, right? So it's all like there are several criticisms of legal arguments that rely heavily on tradition or historical precedents, particularly in the context of gun control and the Second Amendment, right? So it's like here are some issues, right? So here's one, right? Courts may cherry pick certain laws or periods that support a conclusion while ignoring others. This is what I want to just show the bias here, right? So example, in Bruin, the Supreme Court emphasized laws from the 1700s and early 1800s, but critics argued it ignored Reconstruction era or the 20th century regulations that reflect evolving public safety needs. And this is what the AI tries to do. It tries to say evolving public safety needs. These are needs. The public needs to be disarmed. The public needs to not have military-style weapons, right? Even though this is bullshit. So anyway, let's look at it. Tradition doesn't always equal constitutionality. Just because something was traditionally regulated or unregulated doesn't mean it aligns with constitutional rights. Exactly, like this is what I said before, racial segregation, bans on interracial marriage, and restrictions on women's rights were all traditions at one time, yet later struck down as unconstitutional. Exactly. Technological change makes tradition less relevant. But the thing is, I'm sure that it's saying this here, meaning that like, oh yeah, maybe those guns are also unconstitutional. It doesn't mean this in a good way. Okay, so technological change makes tradition less relevant, right? Here's where it really reveals its bias. Problem: weapons technology has changed dramatically since the 18th century. Then this is what they try saying. Example, the founders could not have imagined high-capacity semi-automatic rifles. And here, look, it's not even talking about automatic rifles. Here it's talking about semi-automatic rifles like the AR-15. So relying on the 1791 standards may be inappropriate for assessing modern weapons. Okay, so right here, I was like, okay, you've revealed your bias. You don't know shit about history either, right? So here's what I say to it, right? I don't agree with point 3. The problem I have is that the Founding Fathers, specifically the Anti-Federalists, pushed for the right to bear arms in the face of government tyranny. The Founders didn't say, I guess shouldn't be past tense. The Founders didn't say we needed to bear arms to protect ourselves from petty criminals. They wanted us to bear arms to protect against tyrannical governments. So it doesn't matter what they imagined guns becoming, they wanted civilians to have the same firearms as the government used. If this wasn't the case, they wouldn't have cared about rifles and pushed for only handguns or pistols. At the time, they were called pistols. So it's like, oh yeah, you're absolutely right to push back on that point, and your objection is grounded in a historically valid and widely discussed interpretation of the Second Amendment, particularly from the anti-federalist perspectives. Your view, parodied with government arms, was the point. Right? Exactly. The anti-federalists argue that the people must have the means to resist tyranny, including force if necessary. Right? They didn't say, oh yeah, we need the right to bear arms so you can protect against petty criminals. No. That right was pushed when these common people were pushing back against the strongest military, the strongest government in the world at the time, the British fucking Empire. Okay, it wasn't the British bandits, it wasn't the British petty criminals that were coming over from Britain and trying to get away with some petty crime. No, it was the British Empire. So they were pushing for us to have military parity with an empire. So all these justices that are talking about tradition and historicity, a tradition of regulations, a history of regulations, why don't you guys look at the point, the period in time exactly when the Second Amendment was advocated for and pushed into the Bill of Rights? And actually, you should really look at the original Second Amendment, which was proposed by the states before James the Con Man Madison butchered it, because they made it very clear that the Second Amendment was also to push back or fight against government tyranny. I have a whole video on that. Just go to my videos, then search original Second Amendment. Well, you might learn something new that you haven't heard anywhere else before, even though I'm sure these justices, I'm damn sure that they're familiar with that stuff. But what do? They bury it. They treat you like a mushroom, they keep you in the dark, and they feed you this bullshit. Oh yeah, hey, here's this shit, guys, here's this shit. Don't look at what the people who actually pushed for the Second Amendment actually wrote. Don't look at that. Here, look at what James the Con Man Madison put together on the Bill of Rights, this ambiguous bullshit. Yeah, let's look at that, and then let's look at this bullshit here. And then let's say, oh, no, you average people, you can't possibly be judges. You need to go through all these hoops, and you need to suck all these and bend over for all these corrupt politicians. Then you can be a judge. And I apologize. I know my outburst is probably inappropriate, but this is some serious shit here, people. So Justice Samuel Alito and Neil Gorsuch indicated that they would have granted the challenger's petition. Justice Brett Kavanaugh penned a brief statement regarding the court's decision to deny review. And he's one of the ones who denied the review. This guy, weren't all the Republicans saying, yeah, Brett Kavanaugh, man, yeah, we'll suck every drop. Weren't they just doing that like a couple years ago? It was this guy, right? Brett Kavanaugh? Whatever. Justice Brett Kavanaugh penned a brief statement regarding the court's decision to deny review. He suggested that because, quote, millions of Americans own AR-15s and that a significant majority of the states allow possession of those rifles, the challengers have a strong argument that AR-15s are in common use by law-abiding citizens and therefore are protected by the Second Amendment. Such a ridiculous logic. See, once again, even when you think that they're defending you, what they're actually doing here is implanting a hypnotic suggestion. That, oh yeah, this is what makes them legal. No, it has nothing to do with the history of the Second Amendment. It has nothing to do with the history of tyranny that this country fought against. No, it has nothing to do with that. It has to do with appeal to popularity. Indeed, he posited, under this court's precedents, the Fourth Circuit's decision is questionable, and the court's decision not to take up the case should not be interpreted as an endorsement of it. Kavanaugh observed that with the U.S. Court of Appeals for the First Circuit having decided this issue and several other courts of appeals currently considering the same question, this court should and presumably will address the AR-15 issue soon, in the next term or two. So why not do it now? I don't understand. Why put it off? Justice Clarence Thomas dissented from the denial of review. Because AR-15s are arms, he reasoned, the Maryland law can only be upheld if the state can show that its ban is consistent with the country's historical tradition of gun regulation. And AR-15s do not, Thomas stressed, fall within the historic exception for dangerous and unusual weapons, because AR-15s are not unusual, but in fact the most popular civilian rifle in the United States. Thomas would not wait, he wrote, to decide whether the government can ban it. Particularly when, he said, lower courts in the jurisdiction that ban AR-15s appear bent on distorting this court's Second Amendment precedents. Exactly. They're already... Well, you claim that they're distorting the precedents, but they're really not. But okay, whatever. In Ocean State Tactical versus Rhode Island, the justices rejected a challenge to Rhode Island's ban on large-capacity magazines, which state law defines as a device capable of holding more than 10 rounds of ammunition that can be fed into a semi-automatic weapon. Semi-automatic weapons that use detached magazines allow the shooters to take the magazine out once all the rounds have been fired and swap in a new one. The state passed the law in June 2022, shortly before the court's decision in Braun and after a mass shooting in Uvalde, Texas, in which an 18-year-old with an AR-15 style rifle was allowed to kill 19 students because of law enforcement officers. They forgot all this other information here. And 2 teachers. The law gave Rhode Islanders who already own such magazines approximately 6 months to modify the magazine so that they do not hold more than 10 rounds, turn the magazines over to police, transfer the magazines out of state, or sell the magazines to someone who could legally own the devices, such as a licensed gun dealer or an out-of-state buyer, or a law enforcement officer, because I can guarantee you law enforcement officers are still allowed to have more than 10 rounds in their personal guns. And I'm not even talking about their service guns, I'm talking about their personal guns. So 4 gun owners and a gun store filed a lawsuit challenging the ban. A federal district court rejected their request to temporarily block the law while the challenge to it continued. Yeah, you're a piece of... Look at this. Another court being a piece of... It's like, hey, this law is being challenged. Can you just put a stay on it being like enforced until the challenge is finished? The judge is like, no. No, I don't care if it's unconstitutional or not. We're trying to fuck you, the people, over, so we're going to do that. And then we'll try to clean this up in hindsight, but then in hindsight, it's going to cost you people money. It's going to cost the state money because the states might be sued for this. So what happens? We're at a loss, no matter what. No matter what happens, we're at a loss. No matter what happens, these people are losing money. No matter what happens, the taxpayers are losing money. So regardless, even if these infringements on our rights go nowhere, they're actually going somewhere and they're leaving us at a deficit. They're leaving us with a loss. The gun owners appealed to the U.S. Court of Appeals for the First Circuit, which also left the law in place. Even assuming that the Second Amendment's right to bear arms covers the right to have a large-capacity magazine, the Court of Appeals reasoned the law is still likely to be constitutional. Still likely to be constitutional? What the fuck are you talking about? First, the Court of Appeals explained the Rhode Island ban does not place any meaningful burden on the right to bear arms for self-defense. Civilians rarely, if ever, have to use the rapid and uninterrupted discharge of many shots, much less more than 10, to defend themselves, the First Circuit suggested. Wow. See, once again, according to them, the Second Amendment has nothing to do with defending yourself against a tyrannical government, against a rogue government, against a government that is despotic. No, it has nothing to do with that. It has everything to do with defending yourself against petty criminals and maybe a wild animal. And not even multiple petty criminals, just a single petty criminal, I guess. Because they're like, oh yeah, you don't need more than 10. What if you have a fucking mob of people attacking you? Oh, well, I guess it's mob rule, so the mob gets to attack you and kill you. And then, oh, no, you can't defend yourself against a mob. Sorry. Second, the Court of Appeals continued, the ban is consistent with a historical tradition of regulating firearms to guard against broader threats to public safety. What about fucking a tyrannical government that is destroying the public by putting them in debt, destroying the value of their currency, bringing in a whole bunch of people that shouldn't be here. If you actually look at the Declaration of Independence, one of the reasons why they were declaring their independence from the king, from the British Empire, was because Britain was allowing the what they called the savages to basically enter the colonies and cause all kinds of issues. Just read the fucking Declaration of Independence. You'll see it. You'll know what I mean when you see it, right? So, for example, the risk posed by the presence of large quantities of gunpowder and restrictions on sawed-off shotguns. The gun owners came to the Supreme Court in August asking the justices to take up their case. They emphasized that the ban applies to magazines that tens of millions of Americans, many Rhode Islanders included, have long lawfully kept and borne for lawful purposes such as self-defense. The Court of Appeals used the wrong test, they argued. The Supreme Court's decision in Braun directs courts to consider how a law burdens the right to bear arms, rather than looking at, as the First Circuit did, the magnitude of the law's burden. But in any event, the gun owners insisted. The First Circuit's theory that the scope of the right to keep and bear arms depend on what the government thinks is necessary to exercise it is irreconcilable with the very notion that the Second Amendment protects a fundamental right. Exactly. Now this is like literally the court telling you, yeah, well, you don't need this many rounds in your magazines to defend yourself. I mean, this is insane. This is batshit crazy, and why anybody can be a judge. Moreover, they told the justices, there is no historical tradition in our nation of prohibiting ammunition feeding devices or firearms based on their capacity to fire without being reloaded. Bans on other weapons like sawed-off shotguns and machine guns do not justify the Rhode Island law because those weapons have never been common among law-abiding citizens, and they pose different risk. Jesus Christ, man. People are just so pathetic. Stop using these arguments. Use the real fucking argument. This is when the fucking Second Amendment was made. It was made for this circumstance. It was made for this purpose. Fuck off with your idea that it's about defending yourself against petty criminals. Rhode Island's ban also violates the Fifth Amendment, the gun owners added, which bars the government from taking private property for public use unless it provides just compensation. The law not only prohibits residents from owning large-capacity magazines in the future, the gun owner said, but it also confiscates them from law-abiding citizens who lawfully acquired them long before the ban was enacted. Rhode Island urged the justices to leave the First Circuit's decisions in place. The state still allows gun owners to have semi-automatic weapons, it stressed, but owners of those weapons simply have to change magazines more often with the smaller capacity magazines. This is important, the state wrote, because reports from mass shootings make clear that any pause in fire, such as the pause to switch magazines, allows for precious seconds in which to escape or take defensive actions. This is insane. The Second Amendment was made to fight against government tyranny, for people to be able to defend themselves in their homes against any intruders, whether they're petty criminals or the government themselves. And now they're all like, oh no, we need to now critique, or we need to now like crop the Second Amendment around crazy mass shooters. And then another thing that's said here that's really interesting is that it says the state still allows gun owners to have semi-automatic weapons. Like, oh yeah, it's the state allowing you guys. Yeah, we're still allowing you guys. Don't worry, we'll take that away from you soon enough. The ban does not burden the gun owner's Second Amendment rights, the state argued, because magazines are only accessories for guns, not arms. But the law is nonetheless consistent with a historical tradition of regulating that promotes safety while protecting instruments used for self-defense. Wow. The state also pushed back against the gun owners' contention that the ban constitutes an unconstitutional taking in violation of the Fifth Amendment. Owners of large capacity magazines, the state said, have the free choice to transfer. Oh yeah, it's your choice. Well, no, it's not a choice. It's an ultimatum. And if they don't do this ultimatum, you will fine them or arrest them, right? So it's not a choice. So they have the free choice. And actually, I like how they say free choice, right? It's not a choice, right? They have the free. It's like they just like to sprinkle the word free. Oh, well, we'll sprinkle free here. We'll sprinkle free there. We'll call it the land of the free. And now they might think that they're still free, right? Because they think that we're that fucking stupid. And most of us are that fucking stupid. So anyway, we still have the free choice to transfer, surrender, or modify our magazines to come into compliance. In a brief unsigned order, the court denied the challenger's petition for review. Thomas Alito and Gorsuch indicated without more that they would have granted the petition. So yeah, I was right. This guy over here, who everybody was saying, oh, he's going to be the best Republican fucking pick for the Supreme Court ever. Guess what? He rejected to hear the new petition. Brett Kavanaugh. Sorry, guys. You can go fuck right on off. We'll come around to the AR-15 issue later. We'll do it soon. But guess what? When they do finally get around, there'll be a tradition and maybe some historical precedent for them to just say, oh, we'll keep it in place. Once again, this proves that anybody can be a Supreme Court justice. But anyway, I'm going to end the video here. Sorry for being a little extra uncensored today. Just feeling a little edgy. You all stay optimistic, stay positive, stay healthy, and stay sharp.
You know what I think? I'll tell you what I think. Fuck the courts, that's what I think.